We begin with some news just in from the United States. The U.S. Supreme Court has struck down most of Donald Trump's tariffs on global trading partners. Justices ruled by 6 votes to 3 that Trump lacked the authority under an emergency powers law to impose the levies. This past year, Trump placed sweeping tariffs on dozens of nations that trade with the U.S. The president has called the case one of the most important in U.S. history, saying a ruling against him would be an economic body blow to the nation. Well, let's cross over to DW's Komodowski in Washington, D.C. Misha, tell us more about the Supreme Court ruling.
Well, Terry, the Supreme Court essentially says that President Trump went too far when he imposed sweeping tariffs under a law meant for national emergencies. And those tariffs are basically subject to his great pride. And the decision does not affect all of his tariffs. But it does strike down those put in place under a 1977 law called the International Emergency Economic Powers Act.
What's up, guys? Welcome back. Adam is here, so this has just happened. The Supreme Court, Trump's own reshaped court with his hand-picked supermajority, just ruled 6-3 that he flat out broke the law. Not bent it, not stretched it. Broke it. The court declared in plain language that the emergency statute he used to impose his global tariff regime doesn't give a president that power.
The Supreme Court ruling the president does not have the authority to impose some of his sweeping global tariffs, a decision set to have a massive impact potentially on the economy here at home and also around the world as well. Let's bring in our senior legal correspondent, Laura Jarrett. I know you're sifting through the decision right now. 6-3 decision.
Yep.
What have we been able to glean so far?
Yeah, it's a 6-3 decision, Craig, but we should mention Chief Justice Roberts, Justice Gorsuch, Justice Barrett also joining the progressives here in a major blow to the centerpiece of the president's economic agenda. The High Court today is saying the president essentially overstepped his authority, trying to invoke a law that had never been used before by a president in this way, a statute that says nothing about tariffs, nothing about taxes, and the High Court saying he does not have the authority to do this. This is typically a matter that has been left up to Congress. Every court that looked at this before had said the president had gone too far and said essentially this is a matter for Congress that can delegate some authority to the president, but not all, and certainly not in the sweeping way that he tried to do it.
Congress taxes. Congress levies tariffs. The Constitution says so. And the justices Trump put on that court just told the whole country he ignored it. This is the Supreme Court stating, in a case bearing the name Learning Resources Incorporated versus Trump, that the signature economic bludgeon of this entire second term was illegal from the very instant he first swung it. And here is the gut punch that should make every political operative inside the Beltway physically nauseous. 2 of Trump's own appointees joined that 6-3 majority, his own judges. The very people he placed on that bench to reshape American jurisprudence for a generation.
2 of the president's Supreme Court picks, as well as Chief Justice John Roberts, joined the court's liberal justices in the historic 6-3 decision, ruling that the president exceeded his authority in using the International Emergency Economic Powers Act to impose those sweeping tariffs on numerous countries. Chief Justice Roberts writing, quote, "The framers gave Congress alone the power to impose tariffs during peacetime. The president must point to clear congressional authorization to justify his extraordinary assertion of that power. He cannot." President Trump calling the decision a disgrace while accusing the justices of caving to foreign pressure in issuing this decision.
They looked at what he did and they ruled against him in writing on the permanent record. The court he spent his entire first term meticulously constructing just told him, in the most formal and binding way possible, that he went too far. Now let us be perfectly precise about what we are and are not describing. Trump has not resigned. There is no signed letter of resignation resting on the Resolute desk awaiting a carefully staged photo opportunity. That is not what is happening in a literal procedural sense. But the nightmare ruling itself is absolutely and terrifyingly real. The Supreme Court decision is real. The cascading legal and political aftershocks are real, and they are already beginning to reshape the landscape. What the resignation framing captures, and what makes it resonant rather than hyperbolic, is something that is occurring at the level of political narrative and power dynamics. The architecture of Trump's second-term power is splintering in multiple places simultaneously, and the sound of that splintering is becoming impossible to ignore. The Supreme Court just surgically removed his most powerful economic instrument. More than 70 members of Congress are now on the public record demanding his removal over the Iran threats. Formal articles of impeachment have been physically filed and are now part of the official congressional docket. His own appointed justices cast votes against him in a ruling of enormous consequence. And the suburban communities outside Houston, Texas, just delivered a staggering 31-point electoral swing directly against his party. Every single one of those developments is a crack in the foundation. And when you assemble them together, when you step back and view them as a single coherent image rather than isolated news items, the portrait that emerges is not that of an all-powerful president operating free from constraint. It is the portrait of a president whose grip on power is being actively challenged from every conceivable direction at precisely the same moment. By courts, by Congress, by voters, and by a global community watching in real time as he threatens the annihilation of entire civilizations. That is the nightmare scenario Trump always feared would materialize. And it is unfolding right now, in real time, before our eyes. Here are the unvarnished core facts of the tariff ruling. The case bears the caption Learning Resources Incorporated versus Trump. The final vote tally stands at 6-3. The central legal conclusion is that the International Emergency Economic Powers Act, commonly referenced by its acronym IEEPA, does not authorize the president to impose tariffs. IEEPA is a statute dating back to 1977 that grants presidents emergency powers to address unusual and extraordinary threats to national security or the economy originating from abroad. Trump seized upon this statute aggressively and expansively to justify imposing sweeping import taxes on virtually every significant trading partner the United States maintains. His so-called Liberation Day tariffs, broad duties applied to allies and adversaries alike, China, Europe, Canada, Mexico, were implemented through pure executive action without a single vote of congressional approval. The entire edifice was justified under IEEPA as an emergency economic measure. And the Supreme Court said no. Congress possesses the constitutional power to levy tariffs. That power cannot simply be delegated away to the president through a generalized emergency statute. What Trump executed was a straightforward seizure of power that belongs to the legislative branch, exercising it unilaterally through the executive branch, using a legal mechanism that was never designed or intended for that purpose. And 6 justices, including 2 he personally nominated and shepherded onto the bench, agreed that this constituted unconstitutional overreach. The practical consequences of this ruling are enormous, and they are immediate. The decision struck down most of Trump's Liberation Day and other IEEPA-based global tariffs, leaving intact only narrower duties that are properly grounded in traditional trade laws that actually authorize the specific actions taken, and it forces the administration to begin processing billions of dollars in refund claims from importers who paid those tariffs and are now legally entitled to recover that money. Billions in refunds that the federal government must now pay out because a policy Trump insisted was essential to American economic strength and national security was ruled unconstitutional before it had even been in place long enough to produce its intended effects. Major international policy institutions described the ruling as a major blow to Trump's second-term agenda. Some called it a bloody nose. And Trump himself, before the ruling was handed down, had explicitly warned that such a decision would constitute an economic and national security catastrophe that would gut his leverage with trading partners. He was correct about the leverage component, because the tariffs were never merely economic policy. They were a threat delivery mechanism, a way of communicating to other nations that if they failed to comply with his demands, he would make their exports prohibitively expensive. And the Supreme Court just confiscated that mechanism. The economic bludgeon is gone, and ruled unconstitutional by his own court. What makes the timing of this ruling so politically explosive is that it is landing directly on top of everything else that is happening simultaneously. the Iran threats, the more than 70 Democrats formally calling for his removal, new impeachment articles physically filed and awaiting action, and now the Supreme Court striking down his flagship economic policy in a ruling joined by his own appointees. This is not a single, isolated event occurring in a vacuum. This is multiple major institutional challenges striking at the same moment, each one amplifying and reinforcing the others, each one contributing to an accelerating narrative about a presidency that is colliding with walls from every direction. And the cumulative effect of all of it together represents something genuinely new in this second term. The beginning of a perception shift. From Trump as unstoppable force to Trump as constrained actor. That kind of shift in political narrative can move faster than any single court ruling or congressional action, and once it begins, reversing it becomes extraordinarily difficult. Let us go deeper into what this ruling actually signifies across multiple dimensions, because each layer demands serious examination. This is not merely a trade policy story. This is a story about the fundamental limits of executive power. It is a story about what happens when a president pushes those limits beyond what even a demonstrably friendly Supreme Court is willing to endorse. And it is a story about how the legal and political consequences of this ruling connect directly to everything else currently convulsing the Trump presidency. Once you perceive the full picture, the tariff ruling and the Iran crisis and the impeachment articles and the suburban electoral collapse all merge into one coherent narrative about a presidency being constrained from every direction at once. Begin with the legal significance of the IEEPA ruling because it extends far beyond the specific question of tariffs. IEEPA has served as one of the foundational tools of Trump's entire second-term governing strategy. The theory underpinning its use for tariffs was part of a broader approach, asserting that emergency power statutes grant the president essentially unlimited flexibility to act unilaterally on economic and national security matters without the inconvenience of congressional consultation. If that theory had survived Supreme Court scrutiny, if the court had determined that IEEPA authorizes broad tariff imposition, the implications for executive power would have been staggering. It would mean a president could use emergency declarations to effectively bypass congressional authority on trade and potentially on other economic matters simply by framing them as national security emergencies. The ruling slams that door shut. It states clearly and unequivocally that Congress, not the president, holds the constitutional power to levy tariffs, and that this power cannot be transferred to the executive branch through a general emergency statute. That is a specific and significant limitation on how presidents can deploy emergency powers, and it establishes a precedent that will constrain not just Trump, but every future president who might attempt the same approach with different justifications. Now consider the two Trump appointees who joined the majority. This is the detail that carries the most political weight inside Washington at this precise moment. When Trump's own justices rule against him, it is not merely a legal defeat. It is a signal. It communicates that the court, even a court with a conservative supermajority, has concluded that this particular exercise of executive power was so manifestly beyond constitutional limits that even justices who broadly share Trump's judicial philosophy could not find a path to endorse it. That is a fundamentally different category of loss than a 5-4 ruling driven by the court's liberal wing. A 6-3 ruling where two of your own appointees cross over means the overreach was not a close call. It means the legal argument supporting what Trump was doing was not merely weak. It was so deficient that justices who generally favor executive authority and broad presidential power could not locate a defensible rationale for supporting it. And that assessment, delivered by his own judicial appointees, lands in the current political environment as something far more significant than a routine adverse ruling. It lands as a judgment from people who should be predisposed to support him that he went too far. In a political environment already supercharged with impeachment discussion and Iran crisis anxiety, that judgment carries enormous weight. The economic consequences demand their own careful examination because the refund implications alone are staggering. When the court struck down the IEEPA-based tariffs, it did not merely prospectively prevent new tariffs from being collected. It established that the tariffs already collected were collected without legal authority, which means importers who paid those tariffs, companies that imported goods and paid the duties Trump imposed, now possess legal claims for refunds, billions of dollars in refund claims that the government must process and pay out. That is not a theoretical future cost. That is an immediate and concrete fiscal consequence of the ruling that will manifest in government accounts and budget calculations and trade policy decisions for months and years. And the companies filing those claims, the businesses that reorganized supply chains and adjusted pricing strategies and made capital investment decisions based on tariff structures that just got struck down, they will be demanding clarity and compensation with all the legal resources major corporations can deploy. The economic disruption stemming from this ruling does not conclude with the decision. It is only beginning. Now connect this to the Iran crisis because the simultaneous arrival of these two stories creates something more significant than either one alone. Trump's Iran threats, the whole civilization will die language, triggered calls for his removal from more than 70 members of Congress. New impeachment articles were filed. Human rights organizations are warning that his rhetoric describes potential atrocity crimes. And now, in the same compressed time frame, the Supreme Court strips away his primary economic leverage tool. Consider what that combination means for his negotiating position internationally. Trump's entire approach to foreign policy with Iran and with every other nation he has been pressuring has been constructed upon the credibility of economic threats. The message has consistently been compliance or economic consequences delivered through tariffs and sanctions and trade restrictions. The Supreme Court just ruled that one of his primary mechanisms for delivering those economic consequences was illegal, which means the countries he has been threatening, including Iran, can now observe the Supreme Court ruling and calculate that his economic leverage is significantly more constrained today than it was yesterday. The court ruling and the Iran crisis are not two separate stories occupying different news cycles. They are two simultaneous developments that together reveal a president whose instruments of power, legal and diplomatic, are being stripped away faster than he can replace them. And then there is the looming political dimension, which is where everything else we have been examining, the special election results, the suburban electoral swing, the tariff anxiety, the impeachment articles, all converges into a single picture of what the Republican Party is confronting heading into a midterm cycle. The narrative of Trump as unstoppable, as a force that cannot be checked by courts or Congress or international opinion, that narrative has been the foundation of Republican political strategy for years. It is what makes the entire brand function. It is what keeps the base energized and engaged. It is what makes Republican members of Congress deeply hesitant to break with him. Because breaking with someone who appears to be winning and unstoppable is politically costly, but breaking with someone whose grip on power is visibly and publicly eroding, whose signature economic policy just got struck down 6-3 by his own court, whose Iran threats are generating formal impeachment articles, whose endorsed candidate just lost a supposedly safe district by double digits, that calculation begins to shift. Not all at once, not in a dramatic flood of Republican defections, but incrementally in private conversations, in the individual decisions members make about whether to attach themselves tightly to the Trump brand in their campaigns or create some measured distance. And that incremental shift, driven by the accumulating weight of court losses and electoral reverses and international crisis, is what the resignation narrative is actually capturing. Not a literal departure from office, but a political erosion that is making the second term look less and less like the triumphant return it was supposed to be. Let us break this down into clear takeaways because there is an immense amount happening across multiple fronts. The Supreme Court ruling represents a historic legal rebuke, and the 6-3 margin with 2 Trump appointees joining makes it impossible to dismiss as partisan judicial overreach. Trump constructed his tariff strategy on the theory that IEEPA granted him essentially unlimited emergency power to impose economic measures without congressional approval. The Supreme Court declared that theory wrong, clearly, specifically, and with enough consensus that even justices sympathetic to executive authority could not endorse it. That ruling does not simply strike down the Liberation Day tariffs. It strikes down the entire legal framework Trump was using to govern unilaterally on trade policy. It forces him back to Congress, the institution he has spent his entire presidency attempting to govern around, to obtain authority for any future tariff actions. Forcing Trump to work through Congress on trade policy is not a minor procedural inconvenience. It is a fundamental constraint on his governing approach that he is neither equipped nor inclined to navigate effectively. The ruling changes what Trump can do, how quickly he can do it, and what leverage he actually possesses when he sits across the table from foreign governments. Stripping away the tariff weapon at precisely the moment Iran tensions are escalating is not simply unfortunate timing. It is a strategic crisis. Trump's entire approach to Iran, like his approach to every adversarial foreign relationship, has been built on maximum economic pressure as the foundation of diplomatic leverage. Tariffs, sanctions, trade restrictions. These are the tools he uses to compel compliance. The Supreme Court just ruled his primary mechanism for deploying those tools was unconstitutional, which means his credibility as an economic threatener, already questioned by trading partners who watched the tariff regime get challenged in court, is now formally undermined by the highest court in the land. Iran and every other country he is currently pressuring can point to the Supreme Court ruling and make a simple calculation. His threats carry less weight today than they did yesterday because his own court just informed him he was operating outside his legal authority. That is a diplomatic consequence of the legal ruling that receives almost no attention, and it matters enormously for understanding how constrained Trump's second-term foreign policy toolkit actually is right now. The combination of the tariff ruling, the impeachment articles, and the special election results is creating a political narrative that Republicans cannot easily manage. These are not three separate stories occupying different silos. They are three data points in a single picture of a presidency under institutional and electoral pressure from every direction simultaneously. Republican strategists looking toward the midterms now have to factor in a Supreme Court ruling that stripped away a popular policy tool and generated a narrative of presidential overreach. Impeachment articles on the official congressional record forcing members to take positions on Iran threats and criminal lawlessness charges. And an electoral result in suburban Texas suggesting the brand is generating 31-point swings in districts Republicans should be holding comfortably. Individually, any one of those developments is manageable. Together, they are building a narrative momentum that is extremely difficult to counter because each new development reinforces the others and adds to a picture that persuadable voters in suburban districts are already beginning to act upon at the ballot box. This ruling matters not merely for what it takes away, but for the precedent it establishes and the signal it transmits about what is still to come. The Supreme Court has now gone on record clearly with a specific ruling that presidential emergency powers have constitutional limits, and that using those powers to accomplish things the Constitution assigns to Congress constitutes unconstitutional overreach. That precedent exists now. It can be cited in future challenges to other Trump executive actions that rest on similar theories of expansive emergency authority. Other legal challenges to immigration executive orders, to other economic actions taken under emergency justifications, can now point to this ruling as evidence that the court is willing to enforce those limits even against a president with a friendly judicial majority. Trump's legal team understands this. Republican senators understand this. And the people filing lawsuits against other components of Trump's executive agenda understand this. The tariff ruling is not solely about tariffs. It is a signal about how much further the court is willing to permit executive overreach to extend. And the signal is not much further than this. Here is the fundamental reality. The Supreme Court just ruled 6-3, with 2 Trump appointees joining the majority, that Trump's signature economic policy was unconstitutional. The ruling strikes down his Liberation Day tariffs, forces billions in refunds, eliminates his primary economic leverage tool, and establishes a precedent constraining future emergency power claims. It is landing simultaneously with Iran crisis backlash, formal impeachment articles, and a 31-point electoral swing against his party. The architecture of Trump's second-term power is cracking, not collapsing all at once, but cracking visibly and publicly in ways that are changing how courts, Congress, voters, and foreign governments calculate what he can actually accomplish and what he cannot. The nightmare ruling is real, the political consequences are real, and the accumulating weight of all of it together is creating a midterm environment that bears no resemblance to the triumphant second term that was promised. The next wave of legal challenges is already being prepared, and the door the Supreme Court just opened is one that challengers are about to walk through at full speed.